One of the major highlights of the 2010 Constitution was the introduction of the requirement of public participation in key decisions. In their wisdom, the drafters of the law envisioned a process that would facilitate consultations between the state and its citizens before important decisions are made. But instead of giving voice to the voiceless, the provision in some instances has been turned into an avenue to rubber stamp decisions already made. Constitutional experts now argue that this ought to be relooked into if effective public engagement on issues of national significance must be attained. Kamche Menza examines the best way out of this conundrum of the country, prepares for a possible referendum to amend the Constitution.
The debate surrounding the Building Bridges Initiative's sponsored Constitutional Amendment Bill 2020 has brought to the fore an important provision in the 2010 Constitution: public participation. It is a component that cannot be overlooked in the present-day Kenya. Soon after the BBI bill was forwarded to the county assemblies for consideration, public engagement was needed before the members of county assemblies debated the document. So far, 11 county assemblies have passed the proposed law and one rejected it amid allegations there was no input from wananchi. And in the counties that held forums for public participation, the exercise was either hurried or extended for days.
Public participation hiyo iliweza kuchukua siku 8. Averagely tuliweza kupata kwa jumla watu sio chini ya watu 4,000.
Tuliweka kwa runinga na pia tukaweka kwa magazeti ya kwamba leo hii wana Nairobi wote wakuje hapa waweze kutoa maoni yao.
And the committee and the secretariat went in all the 7 sub-counties undertaking public participation.
This then begs the question, just how effective are these public engagement sessions in giving voice to the voiceless as provided for in the Constitution? Constitutional law experts attribute to lack of a framework that sets the minimum national standard to guide its execution as one of the loopholes in the current Constitution.
The ideal is that public participation should result in the public having an opportunity to influence the substance of that, whatever it is. We are not quite having effective public participation. And where is the problem? In my understanding, the problem is we do not yet have a national standard. We have these provisions in the Constitution. We have in a few statutes, like the County Governments Act. But we do not have a national standard, something that sets the standards, how deep and wide one should go.
Joseph Simeha, a member of the Building Bridges Initiative Steering Committee, says the matter came up as they set out to gather views from the public on how to improve the country's governance.
If you look at the Constitutional Amendment Bill, it has, I think, 6 or 7 laws which it provides that will need to be enacted to give it effect. Even those laws, several of them within a 1-year period. Meaning if we go to, say we go to a referendum by June next year, those laws must be in place. For example, the ones that deal with elections. If we don't have a national standard for public participation, again we will have a fuss in the name of public participation for those very critical laws that are supposed to give these amendments effect in the lives of Kenyans.
Absence of a basic threshold, he argues, weakens public participation in county and national development initiatives.
To judge on whether a public participation process has been effective or not is difficult because we don't have a national standard against which to make that judgment. So therefore, any semblance of evidence that suggests some kind of public participation has happened tends to be accepted even by courts of law.
As a remedial measure, Simeha opines the country has no option but to come up with a public participation policy to guide this process. Kamche Menza for Channel 1 News.